Dear ladies and gentlemen, welcome to today's Members for Members webinar. As we are approaching Brexit final line, the red line, I think the topic of today is extremely important. What's going to happen with the visas and stuff traveling from one country to the other. I'm extremely happy that our member Beachcroft offered this webinar for you all. And I want to personally thank Harald Loeffler and Shahjahan for sharing their expertise today. It's probably, we can only share what we know by today, but you know, work is in progress. So thank you very much. And with this, I will turn over to the expert Harald Loeffler and Shahjahan. The floor is yours, and we are really keen to hear what we need to prepare for. Thank you so much for sharing your expert knowledge with us. Thanks.
Thank you very much. My name's Harald Loeffler. I'm a partner here at DAC Beachcroft and head our German desk. For those of you unfamiliar with DAC Beachcroft, we're an international law firm with over 2,500 employees and 12 offices in the UK and Ireland. And I'm here this morning together with partner Shahjahan Ali, and perhaps Shah, you can also introduce yourself briefly.
Yes, of course. Thank you, Harold. Good morning, everyone. So I'm Shahjahan, or Shahj for short. It can get a bit tricky pronouncing my full name, but for this morning, I'm happy to be called Shahj, so feel free. So I'm a partner at DAC Beachcroft, and I head up the immigration team. So I advise businesses on a whole range of immigration matters, most recently very heavily focused on Brexit, which is of course the subject of our discussion today.
Thanks, Shahj. With the forthcoming Brexit deadline of the 1st of January 2021 and the implementation of new immigration rules and regimes, we thought that it would be an opportune time to give an overview of what's known at the moment and to hear what particular issues concern you at the moment insofar as the ability to travel to and to work in the UK is concerned. In terms of questions, as Frau Hartmann has previously mentioned, it's probably best if we wait for dealing with questions until the end of the general presentation and overview that Shahj is going to give, as I think gradually some of the questions will probably be answered, but there will be quite a bit of time at the end left to ask questions at your end. So without much further ado, Shahj, how does the new immigration landscape for EU, probably better EEA nationals, after the 1st of January 2021 look, and what can we already tell people about this?
Sure, yeah, so the position now is very, very different to what EEA and Swiss nationals have been used to for the last 40 or so years. I think it's useful probably just to recap where we are, partly because it sort of helps to set the scene of the history of all of this, and also partly just to inform and distinguish from the current system and the new system. So just to recap on where we currently are, the UK did in fact leave the European Economic Area on 31st of January, 31st of January 2020, which of course did bring freedom of movement to an end. So the freedom of EEA and Swiss nationals to travel to live, study, work, set up in business in the UK without restriction was brought to an end. Now, operationally, I think it's really important to emphasize just how useful freedom of movement was, and what a complete change it's going to be under the new system, which I'm not sure everyone is prepared for currently, or people were aware of when they voted back in 2016. So operationally, freedom of movement was very simple, very efficient. It allowed EEA and Swiss nationals to simply show evidence of their nationality through an national ID card or a valid passport of a member state, either at border control or to an employer, or even to an educational institution, and that allowed them to have full access to the UK, so they could essentially live, work, study without any restrictions, simply by showing their EEA nationality, proof of nationality. So operationally, the way it worked was you were initially given 3 months to come to the UK and do whatever you wanted, and then if during the period of those 3 months, or sometimes even after, you started exercising what we called treaty rights, then your an EEA national's right to continue to be here was extended for so long as they continue to exercise treaty rights. And by treaty rights, what I mean is by having a job, seeking work, being self-employed, self-sufficient, or studying, by virtue of one of those facts existing. So you could be working and in the UK, your right to be in the UK was continuous until such time as you stopped exercising treaty rights. So very different to the proposed system, which I'll talk about in a moment. Currently, it's an EEA national's rights to be here was by virtue of certain facts being in existence. And actually, after 5 years of exercising those treaty rights, a person automatically acquired permanent residence. So again, a very useful and simple process. Connected with an EEA national's right to be here was the right to have their direct family members, and also indirect family members, which included dependent parents and so on. So yes, what a wonderful system it was, and I'll keep giving a bit of a eulogy on that as we go along. But that was brought to an end technically on 31st of January 2020. Once that happened, however, immediately there was an extension to that through the same legislation, which meant that freedom of movement was extended until 11 p.m. 31st of December 2020. So what does that mean? Well, all it means is free movement continues until the end of the year. And from the new year, from 1st of January 2021, the new system will be in place. Under the new system, there'll be one single system which covers immigration from all over the world, including EEA and Swiss territories. There's quite a lot of new rules that have recently come out. So we've had 500 or so pages of rules setting out what the new system will look like. We're waiting for the thousands of pages of guidance, which are yet to be published. But one of the key features from, I think probably worth pointing out, is under the new system, European EEA and Swiss nationals will have to apply for a visa. So there's no longer this idea of you arrive at border control and show your passport or national ID card and are admitted for 3 months. Those looking to come and work in the UK would have to obtain prior entry clearance, which is just a fancy word for a visa, or entry visa, I should say, before coming to the UK. The only situation where a person might not require that is where an EEA or Swiss national is coming to the UK to visit. So under the new rules, EEA nationals can come to the UK to visit for up to 6 months without getting a prior visa, but they will be subject to the conditions and restrictions that any other visitor is subject to, which means they can't work in the UK whilst here as a visitor, can't carry out business activity unless it's the very limited, narrow business activity that's already enshrined in the visitor category. And of course, one of the new experiences, which I hope none of you will be subject to, is breaching immigration conditions. So when you're here in a visitor visa and you end up working, that is going to be a criminal offence now, which carries a 6-month sentence and a £5,000 fine, or a £5,000 fine, I should say. So it is a very, it's a bit of a leap into the unknown, I think, for a lot of EEA nationals, because there's a lot of opportunity or a lot of risk, I should say, of falling foul of the new system.
That's really interesting, Shahjahan, and looking more at the situation that probably some in our audience will find themselves in. So let's take one of the scenarios that I can imagine might apply, which is that there is an EEA company, they have a UK subsidiary, and they want to employ EU or EEA markedly nationals in that subsidiary in the UK. What's going to be different for them if you are thinking about that scenario?
Yeah, and that I think is going to be a really important topic going forward. And certainly I've been talking to a lot of clients and contacts about this. So going forward, those EEA companies or employers will have to become familiar with what's being described as the new points-based system. It's actually the existing points-based system, which has been reformed a little bit, which essentially requires a sponsor to sponsor a visa under the Tier 2 skilled worker regime. So it essentially employers in the UK who want to employ staff will have to obtain what's called a sponsorship license from the Home Office. I'll talk a little bit later about what that entails, because that is a subject which I could probably talk for 5 hours just on that. So I'll give you a brief overview of the sponsorship process. But essentially, UK employers will have to have a sponsorship license, which is a virtual thing. It's a virtual asset. It allows them to manage their migrant workforce through a government portal, which is known as the Sponsorship Management System. And through that portal, they issue virtual certificates of sponsorship to employees that they want to bring to the UK. And with those certificates, those employees can then make an application for a visa. Now that is a gross oversimplification of the sponsorship system. So let me go into a little bit more detail about these visas, because I think some of this will be very new. I mean, it's new because the rules were just created a week or so ago, and it's worth just setting out some of the key points. So firstly, under Tier 2, so the visa is called Tier 2 skilled worker, and under the category, individuals can be granted a visa up to 5 years. Now, that visa is subject to a number of conditions and restrictions. So it's not like free movement currently, where you enter the UK, and then you can work for anybody you want. You can work at whichever salary level you want. Tier 2 has very prescriptive permissions. And the headline is, you can only work for the employer that sponsored you in the role that they sponsored you for, at the salary level that they sponsored you for, in the location they sponsored you for, with minor changes to location and salary permitted. So, you know, as people get annual increments and perhaps change offices. There is some permission to do additional work outside the job that's known as supplementary employment, but we won't go into that because I think it probably digresses from this topic. But essentially, yes, you can get a visa for 5 years, and you can bring your family members with you, so you can bring a partner, children as dependents. One of the other things I think probably worth mentioning is, from a cost perspective, there's quite a significant difference as well. So free movement rights, free to assert, free to even obtain residence documentation. Tier 2 is very expensive. So employers have to pay what's called an immigration skills charge. So there's a fee that employers have to pay depending on the size of their organization and how long they wish to sponsor a person for. So for a large organization wanting to sponsor someone for 5 years, there's a £5,000 immigration skills charge they have to pay. For a small employer wanting to sponsor somebody for 5 years, it's around £1,500. On top of that, the applicant also has to pay what's known as the immigration health surcharge, which has just been increased to £624 per year the visa is valid for. So over a 5-year visa, we're looking at somewhere in the region of 3,150, something like that, if my maths is correct. And on top of that, still, there's the certificate of sponsorship fee and the visa application fee. So the official fees that an employer has to pay to sponsor somebody under Tier 2, as a maximum, that's really what it is. I think strategically it's probably better to issue shorter visas because you don't really know what somebody will be doing over a 5-year period. They might leave after 2 years when you've invested, you know, £7,000-8,000 in a visa. So strategically, it might be better to get a 3-year visa, which reduces those fees. But that of course is quite new, I think, to EEA and Swiss nationals, that they'll have to pay fees for these visas. The other
umzusetzen und später auch dann den Service und
I'm not sure if that was intentional.
I couldn't quite catch it, I'm afraid. So I think if there's a question, we'll pick it up later on.
Okay, great. So yeah, I mean, the Tier 2 skilled worker, you know, that's essentially what the permissions allow. There is some difference from the current Tier 2 scheme to the new Tier 2 scheme, which goes live at 9 AM on 1st of December, although there's some discussion about whether EEA nationals can actually apply for it until 1st of January. So the difference between the new Tier 2 skilled worker and the existing Tier 2 general visa is there's no longer this requirement to advertise the role. So under the current scheme, if you want to sponsor somebody under Tier 2, you have to prove that there's nobody else in Europe who can do this job. Obviously, that's a legal myth. I've only ever come across maybe 2 jobs where people claim there's nobody else on the planet to do it. But under the new scheme, there's no requirement to do that. The government accepts it's a complete legal myth. It doesn't protect the UK labour market, and actually we'll need a lot of people coming to the UK with their technical skills and abilities to fulfill the wide range of vacancies that we'll have in the new immigration landscape. So that's very important. The other important point to be aware of, and I mentioned this, I don't really enjoy talking about this, but because it was all over Parliament over the last couple of years, this idea of the salary threshold. So for a long time, there was this idea that employees have to be paid at least £30,000 to be sponsored under Tier 2, or whatever is the going rate for that job. And you'd always have to pick whichever is the higher amount. So if you were sponsoring, say, a geotechnical engineer, maybe the going rate for that was £60,000, then you'd have to pay that £60,000 to sponsor the person. So it's the idea was to prevent the domestic labour market being undercut. And there's a lot of debate about this in the Commons, in the House of Commons and the House of Lords in the UK. And eventually the salary threshold was dropped quite significantly. So we are now back to a threshold which is similar to what it was in around 2010, which essentially allows visas to be sponsored if roles are above 25,600 or the going rate, but there are lower levels for people who have a PhD, people who are going to be fulfilling jobs which are in shortage in the UK, and people working in the health and education sectors. So that's one thing to be aware of. There is going to be a salary threshold. You can't sponsor somebody lower than that. So the absolute floor is 20,480, where people have a particular skill or there's a shortage. Below that, there's no sponsorship. So that will cut out, I think, a large number of low-skilled work, but it will still leave open the window for higher skilled workers to come to the UK.
So this will make a real difference to companies employing EEA nationals who not already got EU settlement rights in the UK, or domestic UK nationals. Is that a fair summary that it will really make a difference?
Yeah, I think to answer that question, I think we really have to look at the chronology of what's happened over the last 4 years, 4.5 years since the referendum results came in. There's been a lot of talk about cliff edges, and no deal and all of that, and how the UK businesses will experience significant shortages of labour, and businesses won't be able to fill those roles. And actually, there's quite a lot of truth to that. There was quite a lot of truth to that, but that's been progressively managed to limit or mitigate that. So although we won't see a cliff edge or any of those concerns that people raised previously to the level that perhaps originally people thought we would, there's still a real difference to some businesses because they won't be able to attract the skills and labor without going through these visa categories or these visa routes. I think we might have lost Harald there.
Hopefully I'm still here. I don't know whether you can hear me. I've just switched the camera off because my connection has dropped.
Okay, no, I can still hear you, yeah.
I was going to ask you about a different scenario as well, if you can still hear me.
Yes, of course. Yep, go ahead, Harald, if you've got that scenario.
Yeah, I was wondering, because it might also interest our audience, if rather than thinking about employing somebody over here, if you are talking about sending an EEA national from an EEA country to the UK, and whether that's to work in the subsidiary on for a temporary time, or whether it's to work on a project for a number of months, what would the considerations be under the new regime that are being faced by that company sending out the national?
So this is one of the I think most complex areas with the new system, or certainly, well, I guess what I mean by that is this is one of those things that the new system just doesn't cater very well for. So the reality is it's going to be very difficult to do that unless very limited circumstances are in play, which I'll talk about later. And I think the reason that is the case is, temporary assignments. Let's say if you were a US company sending somebody on a temporary assignment to the UK, that's very difficult to do. Somebody can't just arrive, work for a couple of weeks, and then go. In fact, if they did that, they'd most likely be doing that in breach of immigration law, which I've encountered on a number of occasions. So EEA and Swiss nationals will find themselves in that position where actually temporary assignments are going to be very difficult. And that's because, and again, this is harking back to the end of free movement, is there's no longer that ability. There's just no longer that ability to come and do some work very quickly and leave. People, employees, businessmen, self-employed CEOs, or whatever, engineers, they will always have to have permission to work in the UK before they do that. Otherwise, it is very likely that they'll be in breach. Now, I mentioned there's some categories which will allow that to continue for a limited period, which we're still actually waiting for further details on. So there's very little information on at the moment, but I'll let you know what I know. So there's a new visa category being created. It's got a really exciting name. It's called the Frontier Worker Visa. It sounds a bit like the US frontier, which I'm not sure if that's what they were thinking about when they created this visa. But essentially, the Frontier Worker Visa is for people, EEA or Swiss nationals, who work in the UK but live outside the UK. Now, that might sound quite strange, but actually, we do come across that quite often where, and particularly now because of the pandemic, people working remotely, they might prefer to be, with family and friends in Europe than be in the UK. So the Frontier Worker Visa, it's not created yet, it's still to be created, but the idea is anybody who's currently working as a frontier worker and is a frontier worker before 1st of January 2021 will be able to get a work permit under that category and can continue to work that pattern. As I say, we're still waiting for more details on. I know the regulations which have been put out don't make any sense whatsoever, and we've been, as a group of immigration lawyers, we meet regularly to talk about these things, and nobody really understands how the Frontier Worker Visa currently works. But we'll get more details on that in due course. There's also a special agreement with Switzerland. So service providers from Switzerland who have an existing contract, and by existing I mean any contract that's in place before 31st of December this year, to fulfill contractual obligations in the UK, they'll be able to continue doing that for up to 90 days a year. And that program will run for 5 years, from 1st of January to 31st of December 2025. I think that will be quite handy, particularly as Harald and I both work with clients who are Swiss and come to work on engineering projects in the UK for short periods. So that, I think, will be a saving grace for many. And lastly, and I think this is where most temporary assignments will fall under, it's known as the Tier 2 Intra-Company Transfer Visa. So this is similar to the Tier 2 skilled worker visa in that it is a visa which you can get up to for up to 5 years. It allows you to work for a specific employer in a specific role, and of course carries all those fees that I mentioned earlier. But the difference between the intra-company transfer visa and the skilled worker visa is that the employee has to have been working for a connected entity outside the UK for up to 12 months beforehand. It used to be a really attractive route until progressively it's been made less attractive through changes which prevented intra-company transfer workers from ever obtaining permanent residence in the UK. Higher thresholds for skill level, higher thresholds for salary. So I actually don't think it's a very attractive category anymore, but it's still there for anybody who wants to use it for temporary assignments. Sorry, just wetting my whistle there. The one advantage of the Tier 2 intra-company transfer, I would say, is that unlike the skilled worker visa, there's no requirement to meet this English language requirement. So under the skilled worker visa, an applicant has to show that they have an understanding of English to level B1. I don't think that's going to be a problem with the EEA and Swiss citizens. So the only advantage that the Tier 2 intra-company transfer visa offers, I don't think is particularly relevant for this audience in particular. And given the higher skill level required, so under Tier 2 intra-company transfer, you have to sponsor at least degree level or above, whereas under skilled worker, you can sponsor A level or above. It's just not an attractive proposition. It'll probably be relevant for companies who are sending staff from other countries. But I think given the fact that skilled worker does give a route to permanent residence after 5 years, my recommendation, as it's always been the case, is if possible, go for the skilled worker route.
Thanks. I think probably, if you can hear me still, in the area where we're opening the floor up to questions. And one of the questions that we've had was about studying and attending school in the UK. I don't know whether there will be any significant changes to that.
Yeah. We've had new rules in for students. So the new system for students is in place. However, currently EEA nationals won't be considered under the new student rules. They'll have to wait until 1st of January. But essentially, yes, EEA nationals will need to get what's called a Tier 4 student visa to study in the UK. Now, there is a big question around, and I think it's a concern that's always been there, is what fees will EEA students pay? Will they be paying home fees, which are significantly lower, or will they be paying international fees, which, as many of you will be aware, are astronomical? I think that will depend on the, and I'm not an expert on tuition fees. I just come across it every now and again. I think they will be international fees, but it will be up to the universities in particular to look at circumstances and decide what fees a student should pay. Again, with the Tier 4 student visa, something to be aware of. I mean, it's quite limiting in the sense that you can only study with a sponsor who has a Tier 4 sponsorship license. And as part of that sponsorship license, they'll have a number of criteria that they have to comply with. For example, ensuring that students are attending the majority of classes or seminars, lectures, whatever they are. and other restrictions such as the students not being able to work more than 20 hours a week during term time. So it will be completely different. It's the new category is the Tier 4 student visa. However, it's not, as far as we understand, it's not open yet until 1st of January, even though the rules are in force. In fact, anybody who wants to study next year, or perhaps even starting in March, it might be a good idea to relocate to the UK now and get in under the EU settlement scheme, which is, of course, allows someone to apply for a 5-year pre-settled status or settled status if they've been here for 5 years. That, I think, the government is actually pushing people to do that, saying if you are going to be starting soon, then come beforehand and apply under the EU settlement scheme. Yeah.
And we had a specific question from Alex Altman about EEA employers being able to use the sponsorship license for an EEA worker without a UK subsidiary. Is that a possibility?
Yeah, I mean and I have been asked this question before, and I actually can't see how that is possible without negotiating with the Home Office to try to get to a position where they allow that. And I'll explain why that is. And that will allow me to touch on the sponsorship point, which I forgot to mention earlier. So the whole idea of sponsoring somebody to come and work for you requires a UK sponsor, somebody who is licensed by the, or an organization which is licensed by the Home Office to essentially carry out functions that the Home Office historically used to do. And that includes things like monitoring migrant activity, ensuring compliance with the conditions of the visa. So if somebody's got a Tier 2 skilled worker visa to work as an engineer, they're not then working as, I don't know, a teacher. All of that requires personnel in the UK and an entity in the UK to perform certain sponsorship duties. And the other thing to be aware of is when you get a sponsorship license, you give permission to the Home Office to carry out audits, whether announced or unannounced, at any given point. So if there's no entity in the UK, and it's very difficult to see how somebody could comply with the conditions and requirements of sponsorship under Tier 2.
Understood. And in terms of sending somebody over to visit, to install or provide some kind of service under an existing contract with a UK company, what are the rules here for visas? Does it make a difference whether the contract was in place before the end of the transition period or afterwards? Can you maybe elaborate on that?
Yeah, so this is actually a very, very complex area. So we have the service providers from Switzerland. So any Swiss companies or self-employed Swiss individuals who have a contract in place before the end of this year, they can continue to come and work for 90 days a year to work on those projects. The big question is, though, what about everybody else? And this sadly comes back to what I was saying earlier about free movement ending. A lot of employers will have to get to grips with the fact that this is what free movement means. You can't just send a group of workers to the UK, even if it is for just a few months, without getting an appropriate visa, which allows them to work. So, I mean, in the scenario where, you know, somebody wants to send, say, 20 workers to the UK, the position is no different to, say, an American or Australian company wanting to send 20 workers to the UK, and that is, they'll have to get a visa. They'll have to get presumably a tier 2 skilled worker visa if there's no language issues, or if it'll be difficult to meet the English language criteria, then the tier 2 intra-company transfer visa for all of those workers.
Great. That we actually just got another question in, which was about the advantages of getting a tier 2 intra-company transfer visa in comparison to a tier 2 skilled workers visa.
Yeah, so I actually don't think there is a lot of advantage to getting the tier 2 intra-company transfer visa. So what the tier 2 intra-company transfer visa historically allowed was for a very quick visa to be granted to allow somebody to move to the UK, say within a couple of weeks of you know, starting the process. But the new tier 2 intra-company transfer visa and the new tier 2 skilled worker visa are both very quick. So there is no requirement to spend 28 days advertising, then another few weeks applying for a restricted cause, and so on, which added about 8 weeks to the process. That's all gone with the new skilled worker visa. So in terms of timing, there's very little advantage. One advantage, though, is the fact that tier 2 intra-company transfer applicants won't need to show that they have the English language ability to level B1 of the Common European Framework. That as my understanding is the only advantage. In fact, there's quite a lot of disadvantage associated with the tier 2 intra-company transfer visa. For example, there is a significantly higher salary level that has to be met. Individuals can only be sponsored in roles which are skilled to degree level or above, whereas under the skilled worker route, you can sponsor roles which are A level or above, and the salary thresholds are significantly lower, so 25,000, 25,500 in most cases, but in some cases where people have PhDs or are working in a shortage occupation, it'll be as low as 20,480. The other disadvantage with the intra-company transfer is it doesn't lead to permanent residence in the UK. So you could spend 5 years in the UK under the tier 2 intra-company transfer visa, but then you wouldn't be able to apply for indefinite leave to remain. Whereas under the skilled worker, that will of course continue to be available. That, you know, when the Home Office first took away the permanent residence option for tier 2 intra-company transfer, it did create quite a lot of difficulty for employers who had brought staff over to the UK. They became an invaluable asset, but then there was no way to keep them in the UK, and they had to leave. So I think to avoid scenarios like that, I would think very carefully before deciding whether to use the tier 2 skilled worker or tier 2 intra-company transfer. And I think in most cases, the skilled worker route will probably triumph. I hope that answers that question, Katerina. Okay, so we've had a few more questions in. Okay, so we have one from Jennifer. Regarding visits. Okay, so this, so a few days a month. I guess it's theoretically possible that they would be able to come to the UK on the visitor visa to attend meetings. The reason I say theoretically, it's not to be fancy or anything like that. It's because I do have quite a lot of concern about what people will be doing after those meetings, sorry, one moment. After those meetings are over. So do they come for a day or two and then all they do is attend those meetings? Or in between meetings or after the meeting, are they taking calls which are connected to their work? Are they perhaps working on an assignment? What will they be doing after the meeting? And actually, if what they'll be doing after the meeting amounts to ordinary work, then that is actually a breach of their immigration conditions. So they'll be committing a criminal offense if they are knowingly doing that. And I think that's something to be wary of, because it's so easy, isn't it, with all the advancements in keeping us working, that after a meeting, or sometimes even in the middle of meetings, you're checking emails, you're getting calls, and actually that isn't something that the visitor category would allow. So it does make it very difficult, and individuals will have to be aware of what is permitted under the visitor category, and make sure that they stay within the confines of that. Otherwise, as I mentioned earlier, it's a breach of condition, maximum 6 months criminal sentence, and or a fine of up to £5,000. And we have a related question from Britta. 2-week stay for setting up machinery. So I think, so the one thing I would emphasize with that is the visitor category is actually, I'll give you the full name, which is rather boring. It's called the standard visitor. It replaced all the previous visitor categories, or most of the previous visitor categories. Within that standard visitor category, there are a number of permissions to carry out certain activities. So there's a list of permitted activities that visitors to the UK will be allowed to do. And my recollection is that installing machinery can be covered by the permitted activities, subject to certain conditions being met. For example, that they're not actually working in the UK, and it's for specialist equipment and so on. So potentially it would be covered by the visitor category. Then we have one from Daniel. Okay, very, very interesting. I think there's no reason why somebody or a business couldn't issue numerous short assignments. So the particular scenario that we're asked to consider is 5 3-week assignments during a 12-month period, and whether there's a minimum duration. So the minimum duration is 14 days. So the immigration rules, as they're currently drafted, essentially allow for a visa to be granted for as short as 14 days up to 5 years. I think the advantage of doing that, though, is potentially there is none, because the fees that you'll have to pay for that will be astronomical. So if you have a tier 2 skilled worker visa, which is granted for 3 weeks, you're paying the visa application fee, the certificate of sponsorship fee, the immigration skills charge, plus legal fees with the visa application to get that 3-week visa. Then repeating that 5 times, we're talking potentially into the potentially into £15,000 to £20,000 to do that. I think one way to overcome that would be to get one 12-month visa, and actually explain that the idea is they'll be actually working overseas, but there'll be 5 3-week assignments in the UK during the 12-month period. And the reason I say that is because I've had a number of clients in the past under the old regime where tier 2 workers have spent a significant amount of their time working outside the UK. So their role required quite a lot of overseas work. And of course, that is very different to what Daniel's describing, which is the role is based overseas, but there's quite a lot of UK work. But I think that's something a 12-month visa would probably deal with better, and perhaps at a significantly cheaper and less stressful way. Daniel, I'll keep that in mind and see if there are any changes practically as we actually start operating the new system. But very, very important question, because I think that's something a lot of people will be thinking about. And we've got a question. Sorry, I think Harald's connection isn't working, so I'm taking the questions. So we have a question from Ursula. Where will a normal visitor visa need to be applied? Yeah, so EEA and Swiss nationals won't actually have to, well, I think the question you're asking, Ursula, is where are they granted it? And that is actually at border control. So when you land at the airport or seaport or by train, it will be at that point where you're essentially granted entry as a visitor and subject to the visitor conditions at that point. So it will be at the border as you go through the passport gates. So we have a question from Maren. Maren, are you able to unmute yourself and give a little bit more detail about that? I'm not 100% sure what you're referring to there. Or maybe I'm able to unmute you. Nope, I don't seem to have that function. Does anybody else have able to unmute Maren?
I can try it. Who?
Maren Heller.
I try.
Yeah.
Hello.
Hi, Maren. How are you?
Hi. Good. I just have a simple question concerning this. Do you have like a simple overview that we can provide to interested people to show the advantages and disadvantages like you already lined out, or like just a simple paper where you can see the differences and to make it more clear and kind of like to work with it?
Yeah, I mean, I don't currently have one, mainly because the rules have just come out and we're still trying to understand all the 500 pages of new rules and new categories. What I could do, though, is come up, is prepare a specific briefing or information sheet, if that's what you have in mind, on the work categories. So it could cover something like the skilled worker visa, the intra-company transfer visa, and the visitor visa, which I think will be quite handy, just setting out what the permissions are. Would something like that cover it, or were there any? Did you want anything else covered as part of something like that?
Maybe also the student scheme. That would be also very interesting for me. But yeah, perfect. Like what you just said would be perfectly for me to work with.
Okay, great. Yeah, I'll make a note of that actually, and you'll have to bear with me. It might take me a little bit of time, but I'll put something together and get that sent on to the BCCG so they can circulate it.
Excellent. Thank you very much.
You're welcome. And we have a question from Wilfred on attending a trade show in the UK. Yeah, I mean, when you enter the UK as a visitor, of course, attending trade shows are permitted, and you also have the permission of doing your usual tourist activities, which obviously includes visiting family. The reason I hesitate a little bit is I am aware of situations where, well, let me put it this way, because I'm trying to find a delicate way of putting it. If you have, if you're coming to the UK and you come to the border, and the immigration officer asks, what is the purpose of your visit? And you say, oh, okay, well, I'm coming to visit family, which is the correct answer. And if that's what you're doing, that's exactly what you should say. Some immigration officers can be a little bit trigger happy, and they can investigate, actually, are you just coming for a short family visit, or actually are you going to be staying in the UK? Now, this is something that EEA and Swiss nationals will never, well, at least not since 1972, have had to worry about. But if you have, you'll have individuals coming from all over the world who are subject to this sort of assessment, where if they're coming to visit family, the immigration officer will immediately consider, well, actually, are they going to stay in the UK? So although the rules permit it, the rules allow it, just to be mindful that sometimes it can result in slightly difficult discussions with immigration officers, and the reason I say that is because there are those who will genuinely come for that 2-week family trip, and then there'll be others who use the visitor category to come in and out, for years. So they'll come in for 5 months, leave for a month, come back in for 5 months, leave for a month, come back in for 5 months, and they'll do that for 5, 10, 15, 20 years. And actually what they're doing is, they're not in that situation, they're not a visitor. They're actually basing themselves and living in the UK on that basis. I see Wilfred just clarified. He's talking about a familiarization visit. Okay. Thanks for that, Wilfred. I think good to clarify that. Yeah, I think a familiarization visit, that's fine. I don't have any concerns around that. Then we had a question from Anna. Yeah, so tourists. So tourists are considered within the standard visitor. The important thing to note is you don't actually get granted a physical document when you're entering the UK as a visitor, if you're from the European Economic Area, Switzerland, or other visa-free countries. That's just the permission that you're given, and that's noted somewhere, but you won't actually have a physical visitor visa document unless you specifically applied for it. So hopefully that answers Anne's question. Michael, is there any difference or advantage between applying for a standard visa at the immigration center and simply turning up? Yeah, there is. So I don't know to what extent this will be problematic. It'll really depend on how immigration officers at the border enforce the visitor rules. Historically, for non-EEA countries where people have been coming to the UK regularly, so they've not just been coming for a one-off one-off visit to the UK. They've been coming on lots of visits to the UK for longer than 6 months. So they have 5, 6 over a 12-month period. In that situation, it's useful to get what's known as a multiple entry visitor visa, which can be granted for 12 months, 2 years, 3 years, 5 years. So it's still, that is a physical visitor visa where someone doesn't have to prove each time that they're coming that they're actually a genuine visitor and will leave at the end of their visit, because they've been pre-cleared. Well, I shouldn't use the word pre-cleared because they don't pre-clear anymore, because they've already proven that they're a visitor. That doesn't change the fact that even if you get a multiple entry standard visitor visa, they can still carry out an assessment. So there is some advantage. It can make life a little bit easier. I think practically for EEA and Swiss nationals, it's not going to make that much of a difference. The only caution I'd add to that is it depends on how immigration officers at the border enforce the visitor rules. Okay, I think that's all the questions. I might have missed, if I've missed any, please do shout. But I think I've covered all the questions. The other thing I would just mention is, there's a vast amount of legislation, immigration rules, policy guidance, sponsor guidance, operational guidance that the government has issued and is yet to issue concerning the new system. So it might well be the case that we haven't been able to address any particular questions you have or your colleagues might have. We are running an immigration helpline for businesses, which allows a 30-minute discussion with a member of the immigration team to talk about particular situations. It doesn't formally give legal advice, but it allows an opportunity to discuss things as we've been discussing today. There's a simple form to complete, and our secretaries will just book it in. So we can circulate details to the BCCG, who can forward that on to you if you want to have a talk, if you want to have a chat about any particular immigration issues going forward.
Yeah, dear Harald Loeffler, thank you so much for sharing so much expertise with us. And I think it's a wonderful offer, this free hotline. And of course, we will share the link from today's session with the link for your hotline after this meeting. I can only say thank you again. I hope we're as prepared as possible. If we need an update, we might call on you again or on your hotline. So far, I want to say thank you for all the listeners. Thank you. I've received already great feedback through my personal chat and WhatsApp. So the participants were really grateful to what you presented today. So I wish you all the best. Let's hope that Brexit will not turn out as bad as we expect it to be, and stay in this together. I think we're all friends with the UK, and we want to continue business, and with the help of great partners like DAC Beachcroft and other members, I think our network is prepared. Thank you so much. Stay healthy and have a great day.